Hello guys, welcome to my channel. In this video, we're going to talk about the prospectus and allotment of securities in Companies Act. As you can see, this is a series of bank law officer examination prep. Especially these days, a lot of banking jobs, legal officer jobs notification has come up. And in Companies Act series, we are seeing the prospectus and allotment of securities, especially the types of prospectus. That is, what is a shelf prospectus, what is red herring prospectus, or what is a deemed prospectus, and how allotment of securities happen. These are the often tested area, and to understand and how questions are asked in this particular area of Companies Act, follow this lecture, and we'll get into the topic right now. What you will learn in this video, you're going to learn about the ways to issue securities, what is a public offer, what is private placement, and the rights, which is section 23, and prospectus and its types, that is meaning of deemed, shelf, and red herring. What are the different types of prospectus, and what happens if there is a misstatement in prospectus, and what is the allotment of securities, what are the rules, what are the minimum subscription rules, and what is private placement. Now, as per section 23, there are three ways to issue securities. That is, one is a public offer, private placement, and rights and bonus issues. Rights and bonus issues we can see later, but in this video lecture, we are going to emphasize more about the public offer. So, public offer means an offer of securities to the public at large, and it requires prospectus. That includes both IPO, that is initial public offer, and SPO. So, a public offer means issuing securities at large to public, while a private placement means issuing securities to select group of persons, and there is no advertisement. There are, of course, cap limits of to how much persons you can actually offer this particular private placement, and rights and bonus issues are offered to existing members in proportion to the holdings. Now, what is a prospect? Any document that invites public to subscribe or to buy a company's securities is called a prospectus. It may include a notice, circular, advertisement, or other document that invites. So, a prospectus means any document that invites the public at large to subscribe or buy the securities, and it must be dated and registered with the ROC and signed. Now, there are different special types of prospectus. One is shelf prospectus, red herring prospectus, and deemed prospectus. Now, what is a shelf prospectus? Shelf prospectus is a kind of prospectus where the company issues one prospectus that is valid for multiple issues in 1 year. So, like if the company is planning to go to the market and offer securities multiple times a year, then the company may choose a shelf prospectus. Remember, it is a prospectus that can keep in a shelf, which can be taken whenever the company issues the securities. So that is one special kind of prospectus that whenever you see in the question that says if a company is going to issue securities multiple times in a year, then the type of prospectus the company will issue would be the shelf prospectus. What is a red herring prospectus? So this prospectus is filed before the offer and it does not include the final price. It does not state the final price or the quantum. So whenever you see when the prospectus which does not include the final price or quantum, then that would be called a red herring prospectus. What is a deemed prospectus? Any offer document that is issued by an issuing house. Any document that is issued by an issuing house would be called a deemed prospectus. So these are the special types of prospectus that you must remember. So like I said, you can understand the special types of prospectus. One is shelf prospectus. Remember the keyword that if the company is going to issue multiple times in a year, that would be a shelf prospectus. A red herring prospectus is filed before the offer, like the initial public offers, etc. And here it gives the details of the companies but leaves out the final price. So that would be called as a red herring prospectus. And deemed prospectus is something when the company does not tell the particular document as prospectus. Usually it issues the securities through an intermediary like an investment bank or something like that. Then the law would deem the particular document as prospectus. That is when the offer document is issued by an issuing house. Next, this is a very important thing. What happens when there is a misstatement in prospectus? Now, it attracts both civil liability and criminal liability. What is the civil liability? The civil liability is that the company and the directors must compensate to investors who suffer the loss relying on the untrue statement. And criminal liability, imprisonment and heavy fine, and like it is a fraud which is punishable. So, what is the defense for the directors? A director can escape liability only if there is a valid defense, like he withdrew the consent, he genuinely believed the statements were true. So, like I said, he might escape if there was no intention. He might escape criminal liability, but civil liability can be attracted because it would be considered negligent. So there are minimal narrow defense grounds, but still I would say for the exam and the subject, you must remember that whenever there is a misstatement in process, uh, the mistake attracts both civil liability and criminal liability. In terms of civil liability, is the director who has to compensate to the investors who are actually relied on the particular numbers in the prospectus and invested money and have subsequently lost. And whereas in criminal liability, it would be fraud, because fraud is is actually a statutory wrong as per IPC or uh, the latest criminal laws, BNS. So this is very important concept in misstatement in a prospectus. That is, it can affect both. It can attract both civil and criminal liability. Of course, there are defense. The defense is that the director believed it to be a true statement and he withdrew consent. So, all these are particular narrow defenses available for directors in the misstatement in prospectus. Now, how does the allotment of the security happens? So, no allotment unless the minimum subscription stated in the prospectus received. So, no allotment unless the minimum subscription in the prospectus received, and application money, at least 5% of the nominal value should be paid as application money or whatever the SEBI specifies. And if the application money, if the allotment or the minimum subscription stated in the prospectus is not received within 30 days, the money should be refunded. And in return of allotment, that is, return of allotment is once the allotment is made, it must be filed with the ROC, the Register of Companies. And if it is a irregular allotment, remember the word, it is voidable. The irregular allotment is voidable here. So that is another important thing. It is not void, but it is. So the irregular allotment is not void, it is voidable by the person who has suffered. And securities allotted are entered in the register of the member. So the minimum subscription mentioned in the prospectus must be received. If it is not received within 30 days, then the money must be refunded. The application money is at least 5% of the nominal value, or if it is a different value, which should be specified by the SEBI. The other important concept is the private placement. Now, private placement, like I said, there are three ways in which the securities can be offered. One is by public offer, and the second is private placement, and the third is rights and bonus shares to the existing members in proportion to their holding. Now, in private placement, it offers to a select group via private placement, and it must be less than 200. persons. Now, if it is more than 200%, that doesn't make the allotment invalid, but it makes it as a deemed public offer. It makes it as a deemed public offer. So, like a safe, one of the safeguard mechanism is that because the private placement has a lot of legal rules to be followed, the money received should be kept in a separate bank account, and till the till all the legal procedures are properly verified. Now, no public advertisement should be made because it is a private placement. The key point you have to remember is it is for 200 persons, and if it is more than 200, then it would be deemed a public offer, and allotment should be made within 60 days. Contrasted with the uh, with the public offer, that is 30 days, and if not, it should be refunded with 12% interest per annum. Unlike the public offer, the return of allotment should be filed from form PAS 3 before utilizing the money. So, a quick recap, there are three ways to issue securities. One is public offer, private placement, and rights and bonus issue. Then prospectus means it invites the public at large to buy the securities or invest in the particular company. There are three special types of prospectus. One is shelf, red herring, and deemed prospectus. And misstatement in prospectus can attract civil and criminal penalties. No allotment of a public prospectus without minimum subscription stated in the prospectus. I'm sorry, it's no allotment of the securities. And if if this requirement is not met, refund must be made in 30 days. For private placement, it can be done only till maximum of 200%. If it exceeds 200%, then it will be deemed a public offer. And again, allotment must be made within 60 days. So, test yourself question. You can also test yourself by this question, that a prospectus that does not state the final price or number of securities is called as a red herring prospectus. With this, we conclude the next conclude the current topic. The next topic would be the share capital and the debentures, two ways in which the company raise finances. Thank you. Do share this video with somebody for whom it will be helpful. And if you have any doubt, type in the comment box. I would read it and reply and try and clear your doubts. Thank you.